Ulrich, always good to speak to you. There's two issues I'd like to unpack with you. One is just the wording that was used by the court, this fatally flawed, as I quoted, and then two, the jurisdiction of the public protector. First, fatally flawed by a panel of High Court judges does not go down well for the public protector.
Not at all. It means that she completely misunderstood the facts presented to her, that she misapplied the facts, that she stepped outside of the scope of her jurisdiction, and that she just completely misunderstood the law in applying the functions of the public protector. So fatally flawed in legal terminology means that it is the report that she deposed to was dead from the outset. It didn't mean anything when she put it to paper. So definitely a scathing remark.
Scathing, I think some would say, is putting it diplomatically. Help me understand from a legal perspective, for something to go that horribly wrong in a legal process, from the onset of the investigation to the application to appearing in court, in a situation like the public protector, surely there are legal experts surrounding her in her office to advise her. How could this have gone so horribly wrong, do you think?
No, indeed. You know, we work with the Public Protector's Office quite often, where we assist clients to engage the Public Protector, and there are numerous qualified advocates and legal minds who work under the Public Protector, but she does sign each and every Public Protector's report she signs personally before it is you know, sent out into the media and made public. So she has the final say, and she is the person who puts pen to paper and who signs that document saying that whatever's been written down there has done so with her approval. But, you know, to add to your point, the report was flawed from the outset in that she overstepped her boundary completely and her jurisdiction. She investigated an issue here of a private nature, and why I say that is because it was a donation made towards a presidential campaign, the CR17 campaign, whereas her jurisdiction clearly states that she must investigate matters of a public nature. So in other words, organs of state, people employed in positions such as a minister who oversteps his boundaries or does not act in a certain way that he should. And from the outset, her investigation into this matter was wrong. She shouldn't even have been conducting the investigation that she did.
So if it is as clearly defined as you're suggesting, and I'm sure there's a lot more legalese that goes with jurisdiction, but it seems very clear the distinction between private and public, how is it possible that the public protector even misread what her jurisdiction could have been, despite being warned previously that this could be outside of the ambit of what she's supposed to investigate? It went all the way to the High Court. This couldn't have been the first warning sign she was veering left.
Well, I think you can't even count the cost orders that's been awarded against her on one hand anymore. She's receiving a beating every single time that she goes that she's taken to the High Court. Once again today, she's had a cost order ordered against her on a punitive scale, which means that it's the highest cost order that a person can have awarded against them, and it means that you were completely unlawful in your actions by deposing to this report, which is the court found today. So, you know, I asked the question myself, and you also asked it now. How is it possible for her to have deposed to this report? And, you know, there is investigations being conducted into her now and her position. Parliament is conducting an inquiry, and, you know, I cannot see the public protector being in her position any longer. It can only go up to a certain point. As I said, you know, numerous of her reports have been set aside, and it's been found that she's acted completely in an incompetent manner, and you cannot have a person like that being your public protector.
And this needs to be handled very sensitively, I imagine, especially now if there's going to be a parliamentary inquiry into her conduct as the public protector, especially off the back of this very clearly fatally flawed court application. There are those critics who are going to suggest that Parliament's pushing her out because she went after the president. I imagine Parliament and parliamentary law has to tread very carefully how they handle this now, don't they?
Yes, definitely. It, of course, needs to be a very objective inquiry, and the facts must be looked at objectively. But that's why, you know, the court orders that have been granted over the last year or even more, you know, will come in very handy because it's an objective court. So today's decision was made by a full bench. 3 of the most senior judges in our country reached the conclusion today, and that's based on facts. So I don't think that they, you know, if they stick to keeping the inquiry to what has been found in our courts, then I don't think any fingers can be pointed towards them of not being objective. But I think, one of the difficulties that she is faced with is, for instance, in this matter, there was a big noise made about Bosasa and the corruption, alleged corruption that has taken place in Bosasa. And the minute that it was brought to her attention that there was a donation made by Gavin Watson from Bosasa to Cyril Ramaphosa's son, which turned out to be towards his campaign, I think she was blinded by that fact, and she should not have been. The public protector must be objective in everything that she does, and I think that's where she put her foot wrong in this investigation.
Ulrich Roux, always a pleasure. I appreciate your time coming in to speak to us. Legal analyst and lawyer Ulrich Roux joining us here on Nightline.